Hello everyone, I am Dr. Kalpana. Today we will discuss the salient features of Banking Laws Amendment Act 2012. This Amendment Act was passed in order to amend the Banking Regulation Act and Banking Companies Acquisition and Transfer of Undertakings Act 1970 and 1980. So first, most important key provision of this Amendment Act is that it empowers the banking companies to issue preference shares subject to the regulatory guidelines of Reserve Bank of India. Before we go into detail, we should know what is preference share. So preference share is a concept of company law, which means that is also known as preferred stock, is an exclusive share option which enables a shareholder to receive the dividend announced by the company before the equity shareholders. And again, it is subjected to Reserve Bank of India's guidelines, and it provides bank with an additional avenue for raising capital and supporting growth and expansion. RBI ensures responsible issuance of preference shares. It protects investors' interest and maintaining financial stability. And this framework promotes confidence of the investor and encourages participation in banking business and in this sector. Second key provision of this Amendment Act is that it strengthens investors' right and it protects their financial well-being. This act imposes the cap on restriction on voting rights, preventing concentrated control by a single entity, and it promotes shareholder democracy. For example, no shareholder can exercise more than 26% of voting rights, even if they own a higher percentage of shares. This ensures diversified decision making when it comes to voting by the shareholders. If this cap is not there, then there is a possibility a private entity can exercise that right to that extent that can take the control in decision making. Acquisition threshold Act requires prior approval of Reserve Bank of India for acquisition of more than 5% shareholding and voting right in banking companies that allow for closure, scrutiny, and potential intervention. So if any company or any shareholder wants to hold more than 5% of the share, then there is a requirement of the intervention by Reserve Bank of India. And it is no formula or no rule provided in any law or in Banking Regulation Act that can compel RBI to give that permission to hold more than 5% shares. It is the discretion of RBI, and it's again the power of RBI can impose conditions on acquisition to safeguard the financial stability and prevent undue influence. This protects the banking sector from potential threats and promotes transparency. Next key provision, it is empowering Reserve Bank of India to be a single entity to control all banking companies. Here, RBI can associate enterprise inspection. This act empowers Reserve Bank of India to collect information and inspect associate enterprises of banking companies, enabling comprehensive assessment of their financial health. Board supersession. Here, RBI can supersede the board of directors who are having a lot of power so far as banking company directors are concerned. And banking company and can appoint an administrator in cases of financial mismanagement or regulatory non-compliance. RBI has power to conduct a special audit in case there is any suspicion over the mismanagement of any banking company. Section 30 of Banking Regulation Act enables Reserve Bank of India to order special audits of cooperative banks also. This act aims at promoting financial inclusion. That is one of the most key feature of this Amendment Act to banking laws. Primary cooperative societies. This act requires primary cooperative societies to obtain a license from Reserve Bank of India before engaging into banking activities. So licensing, promoting authenticity and regulation is proper. It is enhancing regulation. This provision ensures that cooperative banks operate under a robust regulatory framework, promoting financial stability and protecting depositors' right and their money is safe. That is the first uh, assurance by RBI. If you are engaged with banking, then we are watching your back, protecting your rights. So have faith in banking system. Expansion of banking services by facilitating entry of cooperative societies into banking sector, the act fosters financial inclusion and expand access to the banking services in underserved areas, means rural areas of India have been underserved since long. So there is an attempt by Government of India and Reserve Bank of India to extend the banking services to the rural areas also. And cooperative banks are district level functioning banks which are extending and serving the rural areas. Another key feature of this act is governance and transparency. So corporate governance has been emphasized, and it is a need for improved corporate governance in banking sector, which promotes transparency, accountability, and responsible decision making, so that investors, right, and people who are having dealing with the banking services are feeling safe, good, and their money is safe. Independence from political interference is another objective of this Amendment Act. So there is a call to further reduce political interference and influence in public sector banks, which are nationalized bank of this country, ensuring their focus remains on sound financial practices only. RBI has been set as single regulator for all banks, streamlining oversight and eliminating conflicting directives from different government agencies. So RBI is the sole regulator in this country so far as banking sector is concerned. Whenever there is a new law, we do have challenges as well as opportunities. So first challenge is comes when we enforce any law or implement any law. So effective implementation of this amendment provisions requires a collaborative effort involving RBI, government, and financial institutions. Technology adoption is another challenge. Banking sector requires to embrace technology to enhance efficiency, reduce cost, improve customer experience. Financial inclusion, a continued effort to promote financial inclusion is crucial, particularly in rural areas and among marginalized communities which are not literate about banking services. Uh, At last, not the least, we are towards a stronger and more inclusive banking system because of this Amendment Act of 2012. So, Banking Regulation Amendment Act 2012 laid the foundation of a stronger, transparent, inclusive banking system in India by continuing to address critical issues and implementing innovative solutions. Banking sector can play a vital, crucial role in achieving economic prosperity and financial well-being for all. So with this, I would like to end here. In the next lecture, I would be focusing on what powers RBI has been given by this Amendment Act, which is a separate lecture. So thank you so much. Have a good day. Take care.